Hi everybody, this is Andy. Welcome back. This video is for the week of, for all the cases for up to June 23rd. I had 4 cases to review for my course, so I'll go through them one at a time. Off the top of my head, case number 4, Canada versus Chhina. I presume that's a correct pronunciation. This particular case reached all the way to the Supreme Court. I'm not doing this case. I'm not allowing enough time to go over this case because it's very lengthy. So I added a hyperlink to a case review that really helped me understand the importance of it. So this, I think it was like 200 odd paragraphs in it. So anyways, I'll go through one at a time, and hopefully I'm going to get something out of it by talking about it. Hopefully this may help you down the road too. Right, thank you. Hi, everybody. So just to reiterate, I'm not an immigration lawyer. I'm studying for my RCIC. These case reviews are part of a course that I'm doing, part of an online course. So the first case is Muzeka-Harasim versus the Minister of Citizenship and Immigration. The appellant applied for permanent residence visas for her parents. And under Canadian immigration law, under Section 38, and also operating procedure OP3, that foreign nationals may be inadmissible for reasons of health. So she got a medical examination for her father, and her father was diagnosed with a heart condition. And so they were, the father was deemed inadmissible, and because of that, under Section 42, the mother was also deemed inadmissible. So in Canadian immigration law, there's 2 relevant statutes which apply to this case. Because the father was diagnosed with a severe medical condition, Canadian immigration had said that he's medically inadmissible on health grounds. And that is found in Section 38, Section 38, I guess, paragraph 1, sentence C, or is it subsection 1, paragraph C? But anyways, it says under health grounds, a foreign national is inadmissible on health grounds if their health condition, and sentence C, might reasonably be expected to cause excessive demand on health or social services. The other relevant regulation is in the Immigration Regulations, Section 34, and regarding excess demand. It says, before concluding whether a foreign national's health condition might reasonably be expected to cause excess demand, an officer who is assessing the foreign national's health condition shall consider any reports made by a health practitioner or medical laboratory with respect to the foreign national, and any condition identified by the medical examination. Also, Regulation Section 20 states the following. Assessment of inadmissibility on health grounds. An officer shall determine that a foreign national is inadmissible on health grounds if an assessment of their health condition has been made by an officer who is responsible for the application of Sections 29 to 34. And the officer concluded the foreign national's health condition is likely to be a danger to public health or public safety, or might be reasonably expected to cause excessive demand. And in my mind, this is the key regulation for this particular case, in that the appellant brought forward their own medical examination on both the underlying diagnosis and whether or not the appellant's father would create excess demand on the Canadian health system. When you read this particular section, it states very clearly that outside medical diagnosis is not accepted only if it's different determination on excess demand and not the underlying medical diagnosis. So this is the URL to the actual case. And I'll scroll down to paragraph 8, where what I just mentioned is really important in that the appellant's family got their own medical diagnosis. And paragraph 8 says, the IED gave little weight to Dr. McDonald's alternative medical assessment for 3 reasons. And in this case, Dr. McDonald is not the panel doctor, but the family's own doctor. It goes on to say, first it held that Dr. McDonald applied the wrong test for medical inadmissibility when he wrote, I've been asked to provide an opinion regarding the father's cardiovascular condition and specifically comment on whether this individual would create excess demand on Canadian health services. As noted above, the IED held that the correct test is whether the father's condition might reasonably be expected to create excess demand. And that's basically the judge's way of saying, is there any difference between this wording and the relative probability of the father's health condition creating demand on the Canadian medical system? It goes on to say, as noted above, the IED held that the correct test is whether the father's medical condition might reasonably be expected to create excess demand. Secondly, the IED held that, in any case, it was not qualified or permitted to depart from the medical officer's diagnosis regarding the father's condition, which goes back to the regulation 24 that I just read. And it goes on, and this paragraph concludes, finally, while the IED is permitted to review whether the father's medical condition would impose an excess demand on Canadian health insurance services, Dr. McDonald's letter failed to adequately address this particular issue. So in paragraph 12, the judge made the comment that the applicant and the appellant, in this case, claims that these issues should be reviewed on the standard of correctness. In other words, they're trying to bring forward de novo evidence of the father's medical condition using their own medical diagnosis. But the judge says, however, in my view, they both involve questions of mixed fact and law and or turn on the interpretation of the IED's home statute. They should therefore be reviewed on a standard of reasonableness. In other words, in my mind, what this tells me is that it's not for the IED to review the medical correctness because they're leaving it up to the panel doctor. And in the act, it clearly states that the panel doctor's medical diagnosis rules in these types of matters. Paragraph 14 says, the IED draws a distinction between the phrase would cause excess demand and might reasonably be expected to cause excess demand. The threshold is reasonable probability, not remote possibility. It should be more likely than not, based on the family circumstances, than the contingencies will materialize. So in paragraph 20, the judge renders his decision, and it sounds like he's had past judgments in this particular area because he's citing a couple of his own cases. And the judge basically says, in the last sentence, he says, even if Dr. McDonald had adequately addressed the issue of excess demand, his findings on this point would be tainted by the fact that they're based on an alternative diagnosis of the father's health condition, which is, again, is not accepted by the IED, and that reinforces the fact that only the panel doctor's medical diagnosis is accepted. And to conclude for this particular case, examination brought forward by an applicant, not de novo, redetermined a diagnosis. That's a typo. Rather, only to sufficiently speak to the issues of excess demand of medical and social services. So again, to reiterate, an applicant is not allowed to bring forward their own medical examination, but instead they're only limited to whether or not the the panel doctor's medical determination, whether or not that will impact the Canadian health system. And the judge, to reinforce his interpretation, the appellant tried to certify a question, and they state in paragraph 22 they want to bring forward to the next level. What is the jurisdiction of the ID when dealing with conflicting medical evidence in a medical inadmissibility of appeal? And the judge refused to let this go forward to the Federal Court of Appeal. In paragraph 25, it goes on to state, the medical officer concluded that the new evidence could modify the medical assessment, and again, in the de novo cases, and recommended a new medical assessment be conducted. So, they were not so hard on their initial, in the initial diagnosis, but it reiterates, the medical officer and allowed in Regulation 34 and make that determination. Again, family can't use their own medical diagnosis. And again, the same cases actually cited in our E-month textbook. And the clearest way of interpreting this case was that the family tainted the medical diagnosis was tainted by the fact that they were based on an alternative diagnosis and not based on the panel doctor's diagnosis. So the next case is Chen versus Canada. And this particular case, the appellant raised a couple of interesting points. This case was actually a fairly short read. And I'll show you the URL here. I believe this is it. No, far away. That's the next one. Here's Chen. So what happened was Chen was a permanent resident. He got divorced from his wife. Sounds like his wife and his daughter bought a house, and they rented it to a tenant. But the tenant started to grow marijuana, and somehow, and it wasn't quite clear in the reading of this case, Chen was involved in the marijuana grow operation, received 2 one-year sentences, and because of that, he was deemed inadmissible to criminality. Chen, he's trying to stay in the country, obviously. He raised a couple of points, and to me, he raised a couple of points regarding reasonableness and whether or not the government had considered hardship to not only himself because of his extreme age, but to his family, because it sounded like he was the source of support to his children in Canada. So he raised a couple of other things. One, it didn't look like when I was reading that it was touched on in great detail, and he raised the fact that China has a death sentence, and because Canada has a process of pre-removal risk assessment before they return somebody to their home country, that wasn't raised in this particular case, and I'll need to do some research about that. It didn't look in this reading, in this particular case file. It was. I don't think it was mentioned. And any kind of pre-removal risk assessment was carried out. So, anyways, that was one issue he brought up. But in my mind, and I focused on this, one of the key issues he raised was that he thought it was unreasonable that the immigration officers did not tell him that refugee applications cannot be made by somebody with a removal order, and in his mind, he should have been given a warning to the fact that if he wanted to apply for refugee status, he should have been told so before the removal order was imposed. And if you want to happen to do some reading, and I think I put this in twice by accident, but under section 99 subsection 3, it says that for refugee applications, claims for refugee protection cannot be made by a person who is subject to a removal order. And that's, very plain English right there. And in this recording, it's probably a little too long for me to get into in great amount of detail, but in enforcement guideline number 6, in section 13 of that, there is a whole section on removal orders, and I think I have the URL up on one of these tabs. Yeah, so here it is. It is under, let's see, review of procedural fairness letters under 44. And under the old numbering system, I think in the court case it was under section 8, but it's been moved to section 13. So procedure having possible claims for refugee protection. So I focus on this particular aspect of the case. The judge said basically, and it's found in paragraph 20, and let me just scroll there. That's Toure, and then this is the right link. Yeah, Chen. Under paragraph 20, scroll all the way down. It says, the judge said the following: only a clear, unambiguous, and unqualified process can give rise to a procedural fairness obligation under the doctrine of legitimate expectations, meaning, whether Chen should have expected to be warned that he should apply for refugee protection before the removal order. So in how I read it is that, in this particular case, that that process is not unambiguous. So that's what I took from. So, if there is a person on the same set of conditions, don't expect to be warned whether or not that person should apply for refugee status before a removal order is given. I notice also in paragraph 24, the judge says, finally, the applicant notes that he does not contest his inadmissibility, which I think he should have done right away, and then that's when the appellant should have considered a refugee application, I believe. It goes on to say, as such, he argues that once a decision was made to refer to the section 44, the procedural fairness letter, report to Immigration Division, it became automatic that the Immigration Division will issue a removal order. Again, during that time, that's when the applicant should have considered that alternative. So in this case, the judge dismissed the judicial review. So the third case is Toure versus Canada. And this Toure fellow, very, very lengthy criminal record. So in this particular case, he was being detained. So this case walks through the relevant sections under Part 14 of the regulations, Section 44, detention, Part 14, detention and release. Regulation Section 244 and 245 are relevant. Section 244 is called factors to be considered, and each one of the paragraphs, it goes on to detail of things to consider, like whether the person is unlikely to appear before examination, is a danger to the public, or is a foreign national whose identity has not been established. 245 itemizes a determination whether that person is a flight risk or not. One of the things that the applicant raised was that he felt that, well, his lawyers felt that uh, they wanted to bring forward the actual CBSSA officer. And let me just pause this really quick. Yeah, so they wanted the actual officer to present his evidence. And in paragraph 13, it says, the person concerned also offered no basis why officers lose credibility is questionable. And there's actually some rules in the immigration division on or when an officer should be present. And I have this URL here, and I copied it. And it's on this page here, and it's under the immigration division rules. And down here, let's see if I can find it again really quick. Yeah, under section 33, application for a summons, a party who wants the division to order a person to testify at hearing must make an application to the division for summons, either orally at a proceeding or in writing. And these are the factors. In deciding whether to issue the summons, the division must consider any relevant factors, meaning these are the rules the immigration division must adhere to. A, the necessity of the testimony to a full proper hearing, and B, the ability of the person to give that testimony. Yeah, so in my mind, I thought that was, I don't know, a bit of a side issue. And I think the main thing of whether natural justice, and I guess by extension, habeas corpus is relevant in this case. And in the Eamon's book, I believe it's the same case on page 984, Toure versus Canada. It says basically, this case, habeas corpus applications are intended to be quick and impose a low threshold on the applicant. And what habeas corpus is under the Charter of Rights under the Charter of Rights that under habeas corpus under the Charter of Rights, everyone has the right on arrest or detention to have the validity of the detention determined by way of habeas corpus, meaning have his charges brought forward, and to be released if the detention is not lawful. So in my reading of the Immigration Act and regulations, I believe that the onus on continued detention was on the authorities on the balance of probabilities versus the charter where it's the applicant that has to show whether habeas corpus was violated. So because Toure was incarcerated for so long, and let me just go back. So I'm on paragraph 136. His record is so long that he's been bouncing in and out of detention / jail for quite a long period of time now. So it was right in front of me just a second ago, and maybe, oh yeah, so here, work permit, rejected the refugee claim, was a warrant for his arrest, he stole some identities, it just goes on and on. So, Toure's argument was, in my mind was that his detention was one indefinite. He never got to see the officer bring forward the charges to him. So that's why he thought this is a case of a habeas corpus. So in the ruling, I mean, I'm obviously going a little quickly because this ruling is fairly lengthy. This presiding judge says that the actual test has been codified in section 248, and that was the other factors in the regulations, the reason for the detention length of time, so on and so on. and now that's been codified. And this judge said basically, well, no, there because of this particular situation, his rights were not violated, and it's not indefinite, even though he's been continuing, this person's been continuously going back to court. And it's particular, in this particular case, this is a very interesting sentence, paragraph 140. The Supreme Court concluded that persons' rights under the Charter are not violated where there is a meaningful process of ongoing review that takes into account the context and circumstances of the individual case. And as you can, as I quickly went through, this guy's got a fairly lengthy record here. So to conclude this case, and I'll be honest with you, I was a little confused, if you can't tell from our reading. But I think one sentence in the Eamon's book brings forward the importance of this case. In page 984, habeas corpus applications are intended to be quick and impose a low threshold on the applicant. The onus largely falls on the authorities to justify the legality of the detention in issue. This stands in stark contrast to the Charter Section 12 applications in there, and that definition of habeas corpus, in which the applicant must create an evidentiary foundation sufficient to meet the high bar required by such proceeding. So, to me, that means there's a different onus in the regulations of the Immigration Act versus the Charter, but I think because it's been codified and the detention review process is ongoing, there is no issue of habeas corpus, even though and in this particular case, even though he's been incarcerated in this case for up to 13 months. So the last case in this video, and it also pertains to habeas corpus, is Canada versus Chhina. So this case went all the way to the Supreme Court. And so naturally, it's a fairly lengthy read. I have the URL in the very first tab, but it was really easy to find. And I was going through and I found this particular website, rightswatch.ca. And I thought, when I read this clarified to me what the relevance of this case. And it's still not clear in my mind. In this particular case, how is it's going to habeas corpus? It's either tweaked to the Toure case, which I just read, or this actually replaces the Toure case. I'm not particularly sure. So, and again, I'm still learning, but there's a few relevant paragraphs here. And to start off, I think I misspoke. I think I mentioned Toure was incarcerated in detention for 13 months. It's actually Chhina that was in detention for 13 months. And he also argued that his immigration detention was unlawful. So this article clarifies how habeas corpus and natural law fits in. It made a comment to another case called the Puero exception, and how it fits in immigration law in that it states if there's a complete, comprehensive, and expert statutory scheme which provides for review at least as broad as available by way of habeas corpus and no less advantageous, then the legislative framework is to be used instead of habeas corpus applications to challenge ongoing detention. And I believe this is relevant to the Toure case too. So, however, one relevant sentence here is that the previous legal proceedings said Well, the trial judge found that ERPA's review process satisfied the PRO exception. The Supreme Court actually disagreed and held that ERPA proceedings do not provide for review as broad and advantageous as habeas corpus with respect to the specific basis upon which Mr. Chhina has challenged the legality of his detention. One important way in which the Supreme Court noted that ERPA scheme fell short is that even though it sets out that immigration detention cases must be reviewed every 30 days, if the immigration officials make out prima facie case to continue immigration detention, and prima facie means that obvious, let me double check. Yeah, based on first impression, so prima facie case to continue the immigration detention, which they can do simply by relying on past decisions from the detainee's hearing, the onus is on the detainee to justify their release, rather than the immigration official to justify the continued detention. Consequently, the Supreme Court held that these reviews are susceptible to self-referential reasoning instead of constituting a fresh and independent look at the detainee's circumstances. What that means to me is that on subsequent detention reviews, the onus was placed on the person being held, and not on the immigration of officials to prove that continued detention is warranted. So there's a balance of where the onus lies, or a change to where the onus lies. So therefore, and this is the key finding, as a result, the Supreme Court concluded that immigration detainees are able to use habeas corpus applications to challenge their ongoing detention instead of having to rely solely on the framework set out in ERPA. This is an important victory in affirming the rights of those in immigration detention, meaning that the onus has been changed. So thank you very much. I'm obviously learning. I would like to have a little more time doing each one of these, but unfortunately time is very tight. So hopefully the next go around I'll have a little more time to review each of the notes a little more thoroughly before I have to upload this to YouTube. Okay, hopefully I'll have some time next few days to continue my work on the Excel file, working on the part-time factors right now. So anyways, take care everybody. I'll see you all soon. Bye.